This is Rob Harkavy from Global Legal Group with John Yanchunis from Morgan & Morgan.
How are you?
So John, I think it's fair to say, without being insulting, we can describe you as a veteran of the US class action landscape, if that's not too offensive. And of course, on this side of the Atlantic, we're taking our first baby steps. And I think it's fair to say that we're learning a lot from the experience. I think in one of your talks just now, you say dates back to 1934 in the United States. And we've got almost a century of catching up to do. And while there's a lot to learn, what negative learnings do you think we can take? How do you think that we can benefit from having a clean slate and doing things differently?
Certainly. So, I think what you could learn is what to avoid, and that is be more selective of the type of litigation that we pursue as class litigation. With so many lawyers in the U.S. And with the ability of any lawyer to pay a filing fee and to file anything, there are not repercussions that are that severe to filing a bad case. So, I tend to advocate and mentor younger lawyers to file cases that have merit, that will provide some real relief to the consumer or society in general.
Now, you've obviously seen developments from people claiming damages, which are fairly easy to quantify, to what's gone on in the internet age with things like sort of data breaches and stuff like that. And it's very hard to actually show damage. But in the same way, if someone breaks into my house while I'm on vacation, rents it out, collects the rent, and then tidies it up perfectly by the time I get back, so I've had no actual damage to show, it kind of feels wrong that you have to demonstrate damage to get some sort of compensation. How is the legislation in the US sort of catching up with that?
So not at the federal level, but at the state level. There are certain states like California which are on the forefront of developing data protection, giving consumers the ability of controlling their information. But in the illustration you just used, where there may not be any tangible damage, there's been gain by somebody who violated your rights. They came into your home, they gained money, and through unjust enrichment or restitution, that is a measurement of damages in those cases where a consumer has lost control of their data, it's been misused, and a defendant has gained. That is the measurement of damage, not necessarily what they've lost in terms of dollars and cents. And we're advocating that in some cases in the U.S. today against some of the big tech companies in California.
Yeah, I'm really glad you mentioned big tech, because there doesn't seem a day that goes by without some sort of class action against Google or Meta or Apple. And I'm very interested because despite various federal rulings in the United States, rulings at state level, European Commission findings in the UK, they don't really seem to be changing their ways. They make noises and say, we'll change our terms and conditions. Obviously, you've got no insight into what goes on behind closed doors in their boardrooms. Do you think they care? Or do you think they're so rich? They think, well, $200 million here, £100 million here, it doesn't really affect our bottom line. So, as I say, I know you haven't got any specific insight into how they feel, but what do you think?
So the answer to the question, can they? Of course they can.
Yeah.
Will they? Not until the repercussions are so great that what they have to pay is greater than what they gain. So, we live in a capitalist society in the U.S. Most of the world is capitalist-based. Companies are based, or the purpose is to make money. And the tension needs to come from the government or the lawyer's side on behalf of the consumers to ensure that in making money, they're not overstepping and abusing that power of whatever service or good they're providing. And again, the American lawyer serves that function, as the lawyers here in the EU and the UK do the same. It's just that we've perhaps come up with a better way in which we measure damages. And of course, in the US, unlike the UK, for instance, the loser does not pay. Now, we have some statutes that have that loser pays, but that does not generally exist unless the litigation is vexatious. It's totally baseless.
Yeah. And thinking of vexatious litigation, there's a school of thought that says that third-party funding, which is virtually essential these days, certainly if you're taking on something like big tech or big oil, how do you assess that? Is it a must-have that we'd rather we didn't have it? Do you think they interfere in that sacred client-lawyer relationship? What do you think the pitfalls are?
It's a really interesting dynamic. We have litigation funding, but not in the same type of model. It's law firms who need money to stake their litigation on behalf. And the litigation funder, much like any lender, will get an interest rate based upon whatever they lend. They don't actually get a piece of the litigation. And that would be very difficult in the American system because it would be somewhat of an infringement or getting in between the lawyer and the client relationship.
Unwanted third wheel.
Right. So what I would say to address that, and of course I'll probably draw some arrows from those funders in the room, is the contingency fee arrangement, where the lawyer receives a stake in the outcome, good or bad.
Yeah.
I mean, the contingency base system is if a lawyer is not able to win that claim, they get nothing.
Yeah.
And the expense and time has been contributed. So when you think about that, that in itself is a deterrent, right? Because you're going to think, I'm going to invest my time and my money on good cases.
Yeah.
I know the litigation funder does that. They're trying to assess that from the funder stage, but they still pay the lawyer. If it was the lawyer who had the skin in the game, who would really lose, you might see a little bit of a dynamic change.
Well, I've got one final question before I let you go, and it's quite specific. I know you've been involved in what over here we refer to as the opioid crisis, which, for those of us on this side of the Atlantic, where we have socialised medicine, there isn't really incentive for doctors to oversubscribe. So it was something that's quite alien to us. It is absolutely horrific what's gone on. And I know settlements are being made all over the place, but is anything being put in place to stop it happening again?
Well, the payment of damages in the billions, and that is being paid today by various companies, whether they be pharmacies or the distributors or the manufacturers, some who've gotten out of business, is a significant deterrent. There have been some incarcerations of doctors who were abusing prescription, but very few. So in the U.S., unless people are put in jail, the only way you can punish them is through the dollar. And I think that has changed behavior. And government, too, has stepped in to regulate opioid distribution, but it's such a problem throughout every city in the country that it's just decimating. It's really an epidemic.
It really does define scandal, doesn't it?
It is the worst that could have ever happened to the American public, and it's even worse than tobacco or asbestos. Scourge.
It's terrible. John, I will let you get on and have a well-earned coffee after 2 panels in a row. Thank you so much.
Thank you, Robert, and thank you for having me.
Yes, thanks, John.
Thank you.